Please take today's presentation as an opportunity to gain information or insight that maybe you didn't have before, but don't take the presentation as a substitute for one-on-one consultation with an attorney who can help you with your personalized plan and needs. The other thing I like to say is that this is sort of a public setting, so as you're asking questions, make sure that you keep personal information private and keep your questions more generalized. All right, so let's talk about estate planning. We're going to kind of lay the foundation of estate planning, and then we're going to dig in deeper and talk about planning to protect assets from a long-term care event. That's really the focus of today's presentation. But before we dig into that, we just want to kind of talk about what does it mean to have an estate plan. And there are some basics that everybody should have covered. And then there's some pieces that may be relevant to you or may not be relevant to you, but we're just going to kind of lay that groundwork. So when it comes to estate planning, really estate planning should answer the question, who's going to take care of you if you become incapacitated or disabled during your lifetime? And then it should also answer the question, who and how are you going to provide for your loved ones after you pass away? So it's really those two basic questions. Under Maryland law, we answer those questions with multiple documents. So when it comes to incapacity or lifetime planning, everybody over the age of 18 really needs to have two essential documents. One is the durable power of attorney. This is a document which allows you to appoint a person or people to make legal and financial type decisions on your behalf if you're unavailable or incapacitated. And the power of attorney is such an incredibly important document. Sometimes it is maybe one of the least expensive documents to create, and sometimes people just kind of brush it off that it's really not that important, or I'm married, surely my spouse can do everything for me. That's certainly not the case, and the power of attorney is a simple, straightforward document that if you do it correctly, it can save a lot of heartache and save a lot of money in the long run. The healthcare directive is sort of the opposite side of the same coin. So if you were to become incapacitated, the healthcare directive allows you to appoint someone to make medical decisions on your behalf. It also can detail your end-of-life wishes. So sometimes we call that a living will, where you can specifically decline artificial life support if you are within certain terminal conditions. You can also designate pretty specifically any anatomical or organ donation wishes that you have in this document. So both are really important, and they really deal with incapacity. Who's going to take care of you if you become unavailable or incapacitated? When it comes to end-of-life planning, a lot of us have heard or may even have a last will and testament. So a last will and testament is a really important document. It instructs our local register of wills of your plan for how your assets will be administered or distributed out after you pass away. Sometimes people think if I have a will, then I don't have to worry about probate. That's not true, so make sure you understand that. A last will and testament really informs how probate will take place, but it does nothing to avoid or minimize the impact of probate. If a client is looking to avoid probate, right, looking to avoid that administrative process through the Register of Wills when they pass away, they should really contemplate a revocable living trust. So that's the next bullet point on this item. A revocable living trust is something that you could create during your lifetime. You would be the creator of the trust, the trustee or the manager of the assets in the trust, and you're the beneficiary of the trust. So you have complete access, complete control of that trust during your lifetime. But if your assets are owned by that trust rather than you as an individual, when you pass away, those assets will be administered by your trust. They won't have to go through a lengthy probate process. Sometimes clients have beneficiaries who are receiving certain public benefits like SSI or Medicaid, and we want to be really careful to plan for their inheritance so that when they receive that inheritance, they don't receive it in such a way that they'll lose those public benefits that are really important to their well-being. So in those cases, there's a lot of times where we would use what's called a supplemental needs trust to hold the assets, shelter those assets, and allow the benefit to supplement those allow the inheritance to supplement the public benefit rather than replacing that public benefit altogether. We also have retirement trust accounts that we prepare for some clients. If we have a client who has really high valued tax deferred assets like 401k, IRA, 403b, and they have a beneficiary that they don't want to have direct access to that money. A retirement account is a way that we can use that money for that beneficiary without giving them direct access. Okay, now I just covered a whole bunch of information because I wanted to lay the groundwork for you and I wanted you to have some basic understanding. But what we're really going to talk about today is planning for a potential long-term care event. And one of the primary ways that we do that in our office is we work with clients to create what we call an asset protection trust. This is a special type of trust that is used intentionally to protect some assets, oftentimes proactively, so before there is a long-term care event. And what we're trying to do is isolate certain assets and cause them to be excluded if we need to apply for Medicaid or VA at some point in the future. Okay, so let's talk about why we entertain that planning with a lot of our healthy senior clients. Okay, so let's talk about long-term care. Long-term care can be really expensive. And so I have some numbers up on the screen to help you understand the cost that we see on a day-to-day basis in our office when we're helping senior clients or their families actually apply for public benefits. So when it comes to in-home care, the average annual cost is just over $56,000 a year for 44 hours per week. Okay, so this is care that might be used to either supplement what a family caregiver is providing, so that family caregiver can go off to work for 44 hours per week, go to the grocery store on Saturday mornings, whatever it might be. But that cost of care is not 24-hour care. So I think it's important to note that information when we look at the number. There are other levels of care where someone might go into a facility. So they might not always receive care at home. They might move into an assisted living facility. So an assisted living facility oftentimes is a place where a person has their own space, their own suite or apartment. Their personal possessions might be there with them. But they participate in community dining experiences. There are nursing professionals and other staff on hand to help with medication management, bathing, laundry services, cleaning, etc. So that's what we're talking about when we talk about assisted living level of care. The typical cost of that care in this area is about $6,000 per month. And then if a client has a need for 24-hour hospital level care, we would call that traditional nursing home care or skilled nursing facility care. That cost is significantly more, so almost $11,000 per month. Actually, it's not uncommon for us to see costs around $12,000 per month for a skilled nursing facility. So we have this conversation about long-term care because it's expensive. And when we are sitting down with families to explore their options paying for long-term care, we want to really just consider what are all of the available payer sources. That's where this planning sort of starts. So a couple things. Clients will come in and they say, well, I have Medicare, right? I'm a healthy senior. I have great Medicare coverage. What kind of long-term care or skilled nursing care will that cover? So when you use Medicare to cover a skilled nursing facility stay, it is really a short-term benefit that you're getting. So the Medicare rules say that you can get up to 100 days of skilled nursing facility care after a discharge from a hospital after 3 overnights in that hospital, okay? So you're really tapped out. Medicare coverage for a skilled nursing facility is really meant to be rehabilitative in nature and not long-term, not a permanent residency situation. You may be fortunate to have something called long-term care insurance. So long-term care insurance is typically something that you purchase when you're healthy. You have to make sure that you paid those premiums and you continue to pay those premiums as long as they're due, so that you get maximum coverage under that policy. Every policy is a little bit different. So one of the things that we do with clients is we're oftentimes looking at that policy to see whether the coverage that they are to get is going to be sufficient to cover the cost of care that they'll need. So if the daily benefit is very low, and we know that the typical skilled nursing facility is going to cost over $250 a day, there might be some gap in coverage. We might need to create kind of a supplement to that long-term care insurance to make sure that the care is fully provided. Another option is that clients, of course, can have personal savings that they'll use to privately pay for their care. And in fact, we're going to talk through a case study this morning. And the first part of our case study really explores this idea of privately paying, just liquidating your assets, privately paying for your care until you run out of money. And so we're going to talk about that specifically. A lot of times people are unaware that there are other options. So that's really, if you learn nothing from today's conversation other than there are options, there are alternatives to privately paying and liquidating every asset and spending every penny that you have, that's what I hope you get today. Other benefits that we look to include Medicaid long-term care program. So this is really where we're going to spend our energy today. So let's talk for a moment about how the program works. If I have a client who is eligible for long-term care Medicaid, they have to satisfy certain medical eligibility requirements. They need to be requiring assistance with certain activities of daily living. Okay, they can't live independently. They require assistance of another person. Additionally, they have to be financially eligible. And so again, today we're going to spend our energy talking about how a person becomes financially eligible for long-term care Medicaid. But once that client satisfies those two eligibility factors, the way that Medicaid works, if I have a client who's in a skilled nursing facility and it costs them $12,000 a year $12,000 per month to live in that facility, the way that Medicaid will work is that their net monthly income will go to the facility to satisfy their patient responsibility. But the balance is going to be covered by Medicaid. So if I have a client whose net monthly income is about $2,000 a month, the total bill is $12,000 a month, they're really getting a benefit of about $10,000 per month once Medicaid is in play and is an available payer source for that care. Another public benefit that we look to for our service eligible veterans or their surviving spouses is the VA pension with aid and attendance. I'm not going to spend a whole lot of time talking about this program today, other than to say that the VA aid and attendance pension benefit can be really valuable for our Maryland residents in particular, because it means that they're able to get some payer source to help pay for care at home. For our Maryland residents, Medicaid long-term care is only available in a skilled nursing facility. So sometimes these benefits pair really nicely together to make sure we're getting the care that we need when we need it. And as our care needs change, the payer sources can change to accommodate our needs. Okay, so I'm flooding you with information. I've already told you to hold your questions, so I just want to give you an expectation here. Sometimes the easiest way for us to learn what can be some pretty dense information, and we're really just skimming the surface here, is for us to learn it in sort of a hypothetical setting. So what we've done is we've prepared a case study. And so I'm going to go through a situation with this hypothetical couple, Bob and Betty, and we're going to talk about their situation as if they had done no planning whatsoever, so that you can understand a little bit how the rules will work, just applying the rules on the surface. We're going to take a break at that point, and I'm going to entertain questions. And then we're going to kind of rewind the tape, and we're going to look at Bob and Betty before they had a need for long-term care, talk about the planning that we might have implemented and how that may have played out differently in their situation. Okay? So let me introduce you to Bob and Betty. Bob is 71 and Mary, I don't know who Mary is. Betty is 69, okay? Bob and Betty have been married for 50 years and they have 3 children together. They own assets including their residence, which they own together. It's valued at $250,000. They own a checking account, they have savings accounts, CDs, maybe there's money markets or brokerage accounts, but when we tally up all those cash type accounts, they have about $225,000 invested in those assets. Bob also has a retirement account, and that retirement account is worth $50,000. So the background is that Bob and Betty have done no planning whatsoever, and unfortunately, Bob suffers a stroke. And we now learn that he needs to permanently reside in a long-term care facility where he will now live for the rest of his life so that he can get the care that he requires. So if we do nothing, if Betty is completely unaware that there's any planning that she can do, the Medicaid rules will work like this, okay? As a married couple, Medicaid says that she gets to keep the house. As long as she's living in the house and it's a jointly titled asset, she gets to keep the house. She also, as a Maryland resident, can keep 2 vehicles. Okay, she can keep their household furnishings, she can keep her other personal possessions. And then the married rules for Medicaid applicants says that if the person who's applying for benefits, Bob, is married, then Bob gets to keep about $2,500 and Betty gets to keep about $128,000. Okay, so combined, the Medicaid rules say they can keep $130,000. So what does that mean for the balance of their assets? It means they're not financially eligible for benefits until they've exhausted the $145,000 that they have in excess of what Medicaid says they can have and qualify for Medicaid. So if Betty doesn't know how to strategically spend the $145,000, what's she going to do? She's going to write a check to the nursing facility month in and month out, that $12,000 per month bill, until she exhausts that $145,000. Okay. I like to take a moment here and just kind of break, because I've been very matter of fact about everything I've talked about. It's very much, here are the rules, here are the numbers. But, you know, we as a firm practice in this area of the law because we want to help families. That's why we do what we do. And when I see the Bettys of the world at my conference room table, and they're in a situation where they've been writing a check and essentially watching the life savings that she and Bob built throughout their lifetime together dwindle away, it's not just a matter of money, right? That financial stress is putting Betty in a really tough situation. And a lot of times, Betty is at her wit's end by the time she gets to my conference room table. And she's very sad, and she's no longer living with the person that she's lived with for all these years, and it's just a really trying time. So I just want to make that point. Part of the reason that we do these presentations, you know, now while many of you are healthy, is because we're hoping to inform you so you can have a different result than what Betty would experience in this case study. Okay. So, it essentially took Betty about a year to spend that $145,000. So it doesn't say this on the slide, but that means after that first year, she exhausted the $145,000, she would have qualified Bob for Medicaid benefits. So Medicaid could have kicked in after that first year, and it would have started providing her some support that she otherwise didn't have, okay? But 3 years after Bob has his stroke, he passes away. Okay, and unfortunately, over that 3-year period, Betty has developed advanced dementia. And unfortunately, her family starts to realize she really can't stay home anymore. She can't stay home by herself anymore. And so the family's in a situation where they're now thinking about appropriate placement for Betty so that she can get the care that she needs. So now Betty is a single person because her spouse has passed away. So I want to talk to you about how the single person rules will play out in Betty's situation. So for Betty, the house is no longer protected. The house was protected as long as she lived there and the married rules apply, but now she's moved into a facility. So that house is now a countable resource in Medicaid's mind. So the house is going to need to be sold and the proceeds spent down. Her remaining cash, so any part of that $130,000 that she kept, it now has to be spent down. And since she's a single person, what she needs to spend down to is $2,500, right? It's that same resource limit that we experienced for Bob. Okay. So practically speaking, if her family, if her children, for instance, don't know any better, and they just write the check for $12,000 per month so that Betty gets the care that she needs, the family will have essentially protected nothing. They will have spent Bob and Betty's entire life savings on their long-term care needs, right? And so this is just a summary of that information. When Bob required care, they spent $145,000 on his care. When Bob passed away and Betty required care, the family spent the remaining life savings. And so their total life savings of $525,000 was spent to pay for their care needs. Sometimes people will say to me, well, what's the problem with that? That was their life savings. They should spend that money on their long-term care. And I don't disagree that that money is there for Bob and Betty. But the problem when we just spend down the money and we've done nothing to be strategic or set aside a nest egg is that when Betty in that situation runs out of money and she's on Medicaid and she has $2,500 to her name, her care is being provided for, and that's a wonderful benefit. But what happens when Betty needs something that Medicaid doesn't cover? What if she loses her dentures or her hearing aids, or she needs new clothing, or she could use an iPad so she could FaceTime with her family and not feel so isolated? All of those things are extra things. And if the family did nothing to set aside a nest egg, then you really have a situation where Betty just simply goes without all of those things. Or if she has good, loving children who are financially stable, maybe they dip into their own pocket and they're spending their money to buy those things for Betty because they can't stand to see her go without. So when we talk about why should we do some planning, it's really first to set aside that nest egg so that there is some money that the family can access and make sure Betty has everything she needs or wants in those end years of her life. And then a lot of times our families are really interested in making sure there's something protected so that when they pass away, there's something to go on to the next generation or those community organizations that they love to support during their lifetime. Whatever it is that they would have said, that's my legacy, they want to fund that legacy. So I'm going to take a break here and take questions. Please bear with me. I am going to do my very best to use the chat feature and not disrupt what you're seeing here. Okay, so it looks like I have 2 questions here. So let me read them and then I'll read them out loud. Okay. So this is a question that we get very commonly, and essentially the question is asking, this is Margaret and Joe's question. So they're saying, if I move to Maryland from another resident, from another state, and I have a will, power of attorney, and healthcare directive from that other state, are they still good here in Maryland? So the answer to that question is those documents are still legally binding when you moved to Maryland. But the problem is they were created under the old state's law. So your attorney in that state was creating those documents to avoid any estate planning pitfalls in that state. Maybe it was tax planning or planning to avoid inheritance tax or something else like that. So the problem is sometimes that while that document might be honored in Maryland, it might not accomplish the same objective in Maryland that it accomplished in the other state. So our suggestion is anytime you move to a new state, you should review your old documents with an attorney in the state where you reside now. Because there may be things that you need to plan for in this state that you didn't need to plan for in the other state or vice versa. Let me see here. So my next question is from Jerry. Okay, so I think Jerry's asking if someone were to own their house jointly with another family member, maybe it's an adult child. The question is that asset protected from Medicaid? So the answer to that question is maybe, right? Typical lawyer answer. It might be protected, but it might not be protected. So it depends, one, if that adult child contributed anything toward the purchase of the property. If not, then when you added that adult child to title, you likely made a gift of that interest in the property. And if that gift occurred, so when you added them to the deed, if that occurred within 5 years of applying for benefits, Medicaid will count that gift against you. And so it could preclude you from eligibility depending on the timing of that transaction. Likewise, it also matters how the title is taken. If there's a right of survivorship, there's a potential to say that if you required long-term care, the transfer was outside of that 5-year look-back rule, then your adult child could sign an affidavit saying, I refuse to sell the property. And that might protect the house. But then there's always the concern that what if your adult child dies before you? That creates some other issues. So Jerry, I'm just going to ask you to stay tuned to what we talk about, because it might be that we offer you an alternative to think about that might be a better solution or a better fit. There's a lot of pitfalls that come in when we just add somebody to title. Okay, there's another question from Jane. Yeah. So this question says, essentially, if our estate planning documents are more than 20 years old, should we update those documents? The answer to that question is absolutely. There's a couple things that have happened. The law is always changing, right? So that's part of it. Even if your wishes were the same 20 years ago as they are today, which I have to say with a lot of clients, that's not the case. We change our minds a lot more than that. So a lot of times if you were coming in to do a review, we could make sure that your documents are current under the existing law, and we could make sure that we capture any changes that you want to make. Additionally, 20 years ago, your asset situation may have been completely different than it is today. Maybe you were unaware of probate avoidance, or whether that was something you needed to entertain. So I just think it's a good idea to update your documents. Generally speaking, I think it's really important to continually maintain your estate plan, meaning it's something that you're at least checking on an annual basis. Is everything the way it should be? Are my accounts titled correctly? Do I have the right people in the right positions? We actually offer a maintenance program for our clients so that we can work with them through that process on a regular basis. A lot of clients might work with an attorney who doesn't offer a maintenance program. And so if you're in that situation, I would say at a minimum every 3 to 5 years, you should be sitting down to review those documents with an attorney to make sure that they're current. I think that I have answered all the questions that were typed in as I was speaking. So this isn't your last chance. There's going to be another chance at the end of the presentation to ask questions, but we're going to redirect our attention now and talk about Bob and Betty as if they had done some planning, right? And how that might have played out differently. So the slide that I've put in front of you is really meant to visualize how we might plan for long-term care with our clients and what we're looking to protect depending on when that client makes contact with us, when we're able to start implementing a plan for long-term care. So for our healthy senior clients, we are talking to every client about the opportunity to plan proactively. And so that's represented at the base of the pyramid. And the base of the pyramid is meant to demonstrate we protected the most assets that we possibly could, okay? A lot of times when we're doing pre-planning, that's when we talk about that asset protection trust that I mentioned early on. When we do that type of planning though, we need to make sure that we are playing within the transfer rules that Medicaid has. So essentially Medicaid has a look back rule, and a lot of people have heard about the look back rule, but there's a lot of confusion out there about what the rule is and how it works. So it's actually pretty simple. When it's time to apply for long-term care Medicaid benefits, there is a question on the application that says, have you transferred assets out of your name and not gotten something in return of equivalent value within 5 years of the date of the application? So we're looking back from the application 5 years prior. If the answer to that question is yes, I have transferred assets, then you need to disclose to Medicaid the value of those cumulative assets throughout that 5-year period. And what Medicaid's going to do is they're going to say, well, today you might be otherwise eligible for the benefit, but we're going to penalize you for those transfers you made within 5 years by withholding benefits for the months we think you could have privately paid for your care if you had kept the gift. Okay, so when we're talking about pre-planning, we are looking to take advantage of that 5-year look back period. So we really want to do that planning while we're young enough and healthy enough that we think we probably have a good 5 years before we're going to need long-term care. So we have a lot of clients who think, you know, they don't like the term elder law, right? They think that's not me, I'm not there yet. But if you're a healthy senior client, that's actually the time where you should be entertaining this type of planning. If you think of a more creative way for me to, something else for me to call it, I'll take it. But I think we all, you know, if you dismiss it, you're missing an opportunity, okay? We also have clients who come in and it's pretty obvious they don't have 5 years before they're gonna require long-term care. Maybe they've had a diagnosis, maybe they've developed Parkinson's or early onset dementia. Something is kind of letting the family know that their health is failing and they probably don't have 5 years before they're gonna need some assistance. But they're not yet ready to go into a facility to start receiving that 24-hour hospital level care. So this intermediate planning is meant to say there are some strategies that we can implement in that interim that we don't need that 5 years to play with. And if we do that type of planning, roughly we can protect about 65 to 80% of the assets if we do planning at that point. And then finally, there's crisis planning. So there is planning that's completely appropriate to do at the last second. We know that there's a long-term care need or the client is receiving long-term care as the family comes into the office, and we can create a plan to protect assets at the last moment. When we do that type of planning, we can protect roughly 50 to 60% of the countable resources at that point, okay? So what this pyramid demonstrates is sort of what you can expect to protect at different phases of planning. But what it doesn't reflect is the clients who do the best are the clients who entertain proactive planning when they're still healthy. And then as they enter into a long-term care event, they also engage in crisis planning to protect more assets. So again, let's look at a case study to help us understand how this kind of plays out. So Bob and Betty, same financial picture. And one thing I want to, we have used numbers that are specifically round, specifically easy to work with, because I'm terrible at doing math in a public setting, right? If I have a calculator in a quiet space, I can do it. When I get a little, I feel like I'm standing in front of my algebra class when I do it in this workshop. So we use these numbers to make it easy to understand. The other thing is, everybody has different assets. And so I don't want you to shy away and think, well, I have much more than that, or I have much less than that. Those numbers will fluctuate, but there can be an appropriate plan even if your financial picture looks very different from Bob and Betty's picture, okay? But we kept the numbers the same. So the joint resident, the cash accounts, and Bob's retirement account, okay? Let's say Bob and Betty, we've backed it up a little bit. And so they're coming to see us when Betty is in her mid-60s, they're both in their mid-60s, okay? And so more than 5 years before Bob requires care. When they're sitting at our conference room table, we explain to Bob and Betty that we can create an irrevocable asset protection trust to kind of effectuate that base of the pyramid, that proactive planning, okay? So here is what the irrevocable trust looks like. When Bob and Betty transfer assets into that irrevocable trust, I want it to be a gift. I want them to give up enough control of that trust so that the assets in the trust, when they apply for Medicaid in the future, are not countable. Bob and Betty do not have enough control over those assets, so Medicaid says they're not available to pay for your long-term care, okay? So if I'm going to picture the irrevocable trust, I oftentimes picture it like a box with a lid on it and a lock on it, because Bob and Betty have to give up enough control of the assets that they're no longer countable from Medicaid's perspective. So that means that when they're choosing who's going to manage the trust, they're not going to select themselves. They can select anybody but themselves. So they might select all 3 of their children, maybe in successive order. They love their children, they trust their children will cooperate with any efforts that they want to make with respect to the assets in the trust. So they would be appropriate people to appoint as a trustee of that irrevocable trust. Likewise, the trust is going to be written so that Bob and Betty will not have a right to go to their children and demand money out of that trust. If they could do that, Medicaid would require them to take all the money out and spend it on their care. But we still want there to be a way for the trustees to get money out of that trust if it's needed, okay? So Bob and Betty are going to accomplish that by appointing what we call lifetime beneficiaries. It sounds like a mouthful, but it's actually just what it sounds like. It is the person or people who can benefit from the trust while Bob and Betty are still alive, okay? And we can restrict both the income and the principal of the trust to only the lifetime beneficiaries, which is going to fully protect everything inside of that trust. When Bob and Betty pass away, that trust is going to say, here's how I want everything to be divided up. So whatever they would have entertained in their will, that's essentially the way the trust is going to play out when they both pass away. Now, when it comes to their residence, a lot of times people put their residence into an irrevocable asset protection trust, okay? The reason for that is, even though Bob and Betty can't require the trustee to sell the property and give them the cash, they can retain an equity. So the trust will say that nobody can kick Bob and Betty out of the house, nobody can sell the house without their permission, no one can charge them rent. Likewise, the trust will say, and Bob and Betty continue to be responsible for all maintenance, taxes, insurance. So there's no shifting of burden between Bob and Betty and their children. It really feels exactly the same, okay? So when we explain this trust to Bob and Betty, they decide they want to put their residence into the trust. So we deed the residence into the trust. Likewise, when they look at their total life savings, they think there's about $125,000 of their savings that they don't need to rely on during their happy, healthy retirement years. So they're going to put $125,000 of their savings into the trust with the residence. Now they still have $100,000 of savings between the two of them, and much of those assets would be subject to probate if we just left it in their names. So if we talk to Bob and Betty about avoiding probate, making things as easy for their family as possible, they're going to take the remaining $100,000 and put it in a revocable trust. Remember what I said about the revocable trust. This is a trust that they're going to have complete access to, complete control of. So no one, they're going to be the trustees, they're going to be the beneficiaries. So they have unfettered access to this particular trust. The retirement account that Bob has is a tax-deferred account. Tax-deferred accounts also allow us to name beneficiaries. So if they end up telling us, you know, no matter how my assets are titled, I want everything to benefit each other. When we die, we want everything to go into 3 equal shares with the kids. We're not going to change title of the retirement account because that would be a taxable event. Instead, we're just going to update the beneficiary designations so that Betty is the primary beneficiary and then the 3 children are the contingent equal beneficiaries. All right. I forgot that I had this slide here. Look, I just went through all of this. Sorry about that. This is just a summary of that irrevocable asset protection trust. So as I was talking through that trust, this is the slide with bullet points that kind of gives you all the restrictions, all the requirements that we're trying to satisfy to get the protection that this trust offers. So just to kind of reiterate some things, we won't cover all of these things again, but it is an irrevocable trust. So when Bob and Betty create the trust, they're specifically saying they'll give up the right to make any amendments to the trust in the future. There's a caveat there if they end up changing, you know, everything to the 3 kids when they pass away. There is a way for them to redirect the death benefit after they create the trust. But other than that, the trust is really unchangeable. So they need to make confident decisions about who the trustees are, who the lifetime beneficiaries are. It's really important to understand that just like for Bob and Betty, they put some of their assets. They never dumped all their assets into the trust. As I'm talking to clients about what they should put in the trust versus what they should keep access to, I'm really thinking about their healthy, happy retirement years. Yes, we want to protect maximum assets, but I don't want Bob and Betty to feel restricted or like they have to ask their children for money if they need something during their retirement years, those healthy years. So we're looking at that. And a lot of times clients come in understanding what they might want to put into that trust, or they might consult with their financial advisor or their CPA to better understand what they should contemplate putting in there. We talked about that the 5-year look-back rule applies. So we want to transfer the assets. We want to clear 5 years then before we're applying for care. We talked about the trustee is someone that Bob and Betty choose. They retain the right to reside in their residence. I do want to comment here because this gets a little bit to Jerry's question about maybe adding somebody to title. When we transfer the house into this trust, we're making a gift at that time. But when we transfer it into the trust, I want you to kind of think that the trust insulates that asset then for the rest of Bob and Betty's life. So as long as the house is in that trust, it can't be subject to the divorces, lawsuits, creditors of those adult children who are the lifetime beneficiaries. They are people who can receive money out of the trust, but they don't have to. So this is a much less risky option than an outright gift to those children. Assets inside of this trust avoid probate. Just like that revocable trust that I talked about, both trusts are going to avoid probate. It's just that the irrevocable trust also provides long-term care protection. There's a lot of tax advantages to gifting to a trust versus gifting to a person, especially when it comes to real property. So if there are questions about that, we can entertain it also. So let's play Bob and Betty's scenario out a little bit. Okay, so after Bob and Betty do their planning, we get their assets in alignment with the plan, everything's working like it should. 6 years later is when Bob suffers his stroke and requires skilled nursing facility. So now Betty, who's done proactive planning with our office, she's going to come back to us. As soon as she realizes that Bob is going to need to stay in a facility, she comes back to our office. And she might remember that pyramid that we talked about. And she might remember that there was planning to do when they were healthy, and then there was planning to do when they weren't healthy any longer. So now we're going to contemplate doing crisis planning so we protect maximum assets for Betty when Bob requires care. Okay, so sitting down with us, the first thing we're going to determine is what's countable from Medicaid's perspective and what's excluded from Medicaid's perspective. So all the assets in that irrevocable trust are off the table from Medicaid's perspective. So the residents and the $125,000 of cash are completely protected, 100% protected. Betty still gets to keep up to 2 vehicles, household furnishings, and other possessions. But now under the married rules, her financial picture looks a little different from Medicaid's perspective. So that married rule that we talked about is going to be applied a little bit differently. So essentially, Medicaid says that Betty can keep the greater of half of the countable resources, or that $130,000 figure that we talked about when they did no planning. So before that, if we had split the assets 50-50, she would have had more than $130,000, so she's capped at $130,000. But here, when we look at the countable assets, which total $150,000 because of that proactive planning that we did, she gets to keep half, so $75,000. Okay, so what are we going to do with the other $75,000? It's our objective to get Bob qualified for benefits as quickly as possible so Medicaid starts paying for his skilled nursing care, rather than us using all available resources to pay for his care. So here's some ideas for how we can strategically spend that $75,000. And the idea here is that we want to spend money on things that Medicaid isn't going to count against Bob and Betty. So some things that are excluded under the Medicaid rules include prepaid funeral arrangements, purchasing burial spaces and burial items, not only for Bob and Betty, but could be for their children, the spouses of their children. So that's a way of spending money on something that would be protected. Maybe Betty and Bob have 2 old vehicles, and Betty really would do better just having one single vehicle that's newer and doesn't require as much maintenance, is more reliable. Betty could trade in the 2 vehicles or sell those 2 vehicles and purchase a new vehicle. And any of that cash that she uses to purchase the new vehicle will be protected because that vehicle is an excluded asset. Betty could also determine that she wants to make home improvements. So as she's spending money on improvements to the residence, which she gets to keep, that is money that's just money she's permitted to use. She's permitted to do that. She might pay down some other debts if they have some credit card bills, if there's a medical bill that needs to be paid. Using that $75,000 to satisfy those debts is a good way to strategically spend down the resources. There may be taxes due. If, for instance, Betty decides to liquidate Bob's IRA, there are going to be taxes due, and those taxes are something she's permitted to use the $75,000 on. Likewise, professional fees. So a lot of times when we're implementing this planning, there's additional attorney's fees that are due to us to help Betty through that process to actually implement the plan on her behalf. There could be CPA fees, financial advisor fees. Any of that type of expense is all something that Betty is permitted to spend the $75,000 on. But let's say in Betty's situation, everything, she's already done all these things. Her car is perfect, her house is perfect, she did prepaid funerals years ago, there's nothing else to spend the money on. What's another way that she could use the $75,000? So, I don't know how to go back. Sorry, I hit the button. So that last item on this slide references a Medicaid compliant annuity. So a lot of you might have financial advisors that you work with, and you might be sitting here thinking, I've never heard of a Medicaid compliant annuity. I'm going to ask my financial advisor about that. Don't, because a Medicaid compliant annuity is not something you should have during your healthy, happy retirement years. A Medicaid compliant annuity is something we only look to apply for in a situation like Betty's in, where she's looking to immediately qualify for her husband for long-term care Medicaid. And in essence, what we do is we take the $75,000 that Bob is over-resourced by, and Betty's going to invest that in a Medicaid compliant annuity. That annuity is going to pay a monthly stream of income back to Betty as the annuity pays out. Okay, so the Medicaid compliant annuity, when we convert the cash to the annuity, it's now an excluded resource for Medicaid's perspective. To be a Medicaid compliant annuity, the annuity has to be a single premium, so the full $75,000 is invested in the annuity. It's immediate, so as soon as you purchase the annuity, it's going to immediately generate a stream of income back to Betty. And the primary beneficiary on the Medicaid compliant annuity, even though it's Betty's annuity and she's not applying for care, it actually has to name the state of Maryland as the primary beneficiary. And if Betty were to die before Bob and that annuity had anything left in it, essentially the state has a right to recover from that annuity as much as it paid out for Bob's benefit while Betty was still alive. Okay. The hope is always, though, that Betty outlives the term of that annuity, okay? So that annuity can't be any longer than Betty's life expectancy, but there's a lot of times where we pick the shortest annuity possible because we want to get that money out and back to Betty as quickly as possible. Okay, so we got Bob eligible for benefits. Not a year after he went into the facility right away. Still though, Bob lives for another 3 years at the facility. Betty develops dementia. Betty requires long-term care. So now, considering all the planning we've done for the family, it's now Betty's turn. We look to her financial assets, and a lot of times it's her adult children who are coming in to see us to do this planning for her. And this is where I'll put a plug in for the power of attorney. That durable power of attorney is such a critically important document. And if it doesn't give Betty all the rights, all the authorities to do planning that Betty now can't do because she's incapacitated, that power of attorney would be problematic. But we prepared the power of attorney, so I don't have any doubt that that power of attorney includes all the authorities that it needs to include. So let's assume that Betty's adult child is sitting with us at the conference room table, and they're saying, you know, you did all this planning for Dad. Is there anything else that can be done for Mom? So we're going to look again at all of Mom's assets and consider what's countable from Medicaid's perspective, what's excluded. So again, everything in that irrevocable trust that we did 9 years ago now is all protected. So the residence and the $125,000 still protected. But remember, Betty got to keep $75,000 outright when we qualified Bob for benefits. Then she converted another $75,000 into an annuity that's now fully paid out to her. So the end result is she now has $150,000 of remaining cash. And from Medicaid's perspective, the $150,000 is countable when Betty applies for Medicaid. And remember, as a single person, Medicaid says she can only have $2,500. So what are we going to do to get Betty immediately eligible for the benefits? Okay, so we're going to assume that we already entertained all those crisis strategies, prepaid funeral. We already took care of that, really. And so now things are probably a little bit simplified. So the family is, again, going to use a Medicaid compliant annuity, but they don't have a spouse who's healthy to shelter that annuity. So we're going to use it in a little bit of a different way. So we take the $150,000 and roughly half of that money, we're going to gift it. And we can gift it right to that irrevocable asset protection trust that's already in existence. Okay, so $75,000 we're going to gift just before we apply for Betty's Medicaid. When we apply for Medicaid, we're going to have to answer that question about prior transfers. Yes, I transferred assets within the last 5 years. In fact, we transferred assets just last week. When we do that, remember what Medicaid's going to do. They're going to assess a penalty for that $75,000 gift. So what we needed to have done simultaneously is take the other $75,000 and invest that money in a Medicaid compliant annuity. That Medicaid compliant annuity is intended to pay Betty exactly the income that she needs month after month after month, so that when she's privately paying because she's serving out the penalty that Medicaid assessed, she has exactly enough income to privately pay for her cost of care. At the end of the term of that annuity, Betty will have received all the income back, and that annuity will be done, terminated. But at the same time, the penalty period for Medicaid will end. So as that penalty period ends, Medicaid then starts picking up the bill. Okay? So the Medicaid compliant annuity paid out to Betty, and it was giving her additional income. But that additional income was serving a particular purpose to essentially cure the monthly shortfall she otherwise would have experienced. So she had exactly what she needed to privately pay during that intentional penalty period that we created. Okay. So we protected another $75,000 doing this crisis planning. Okay. So now in that irrevocable asset protection trust, there's a house, plus there was the $125,000 of cash that they initially put into the trust. And now there's an additional $75,000 that we were able to protect at the last second. So all that money, or all those assets sitting inside that irrevocable asset protection trust. Remember early on when I said, why wouldn't you just spend every penny you have and then rely on Medicaid when you're out of money? This is why, right? By doing this type of planning, Bob and Betty sheltered a really healthy nest egg. So now if Betty loses her dentures or her hearing aids, or she needs the iPad to FaceTime with her family can access her money. The trustee can distribute money to any or all of the lifetime beneficiaries. Those lifetime beneficiaries, her child or children, can take that money, purchase the dentures, the iPad, whatever. Okay? And in that way, Betty is never going without those things that give her the best quality of life. And her children are also not dipping into their own pocket or just watching her go without those things. It also means, because Bob and Betty protected such a healthy nest egg, that they're probably not going to exhaust that trust during Betty's lifetime. And so remaining assets will be divided among the 3 children, just like she and Bob intended to protect all those years ago sitting at our conference room table. All right, so this is just a summary of the money, right? If we did no planning, we show you how much we spent at each level of care. And as they say, no one gets their lunch for free. Even when we created a plan, there was private money spent on care, but by doing strategic planning, Bob and Betty spent a total of $75,000 on their care versus the $525,000 on their care. So this really highlights the difference in not having a plan versus having a plan. So I'm going to get to questions, I promise, but I do want to go through some common myths about Medicaid or planning to become eligible for Medicaid that we hear quite often. Okay, so the first one actually touches on the power of attorney that we talked about early on. It says, if I'm married, I can do everything for my spouse. It's not true. So in Bob and Betty's situation, Betty needed a power of attorney to authorize her, actually, can you hold on one second? I need to get an electric cord, so if you'll just bear with me. Megan, can I ask you to cover this slide for me?
Absolutely.
Thank you, ma'am.
Sure. Always nice to be able to tag team as a group. So common planning myths. If I'm married, I can do everything for my spouse. So we see this come up a lot where families believe that in my power of attorney, I need to name other people like my children, because surely my spouse can just automatically work in my behalf, make legal and financial decisions for me, based on our marriage. Not true. I think that sometimes it feels that way inside a marriage because there are joint assets. So if I have a jointly held checking account, which would be pretty common for a married couple, then it feels like my spouse can act for me because of our marriage, when actually my spouse can act for me because he or she is truly a joint owner on that account. So really good examples for this myth would be our retirement accounts. So a retirement account is almost always an individually held account. Megan Ziksinski has a 401k with whatever company. If my spouse, if I don't have a power of attorney that names my spouse as being able to make those legal and financial decisions for me, then heaven forbid if my family ever needs those resources for any need, including long-term care, then my spouse has no access to me, to that asset, even though my spouse might be named as the beneficiary on that account. That doesn't come into effect until my passing, where during my lifetime, I could be ill, incapacitated, or otherwise unavailable to access those accounts, where if I had a power of attorney naming my spouse, he or she would be able to access that for me. Leslie, do you want to jump back on, or do you want me to?
Sure, that was a perfect, thank you so much. I appreciate that.
Sure.
Okay, so another myth that we often hear is I don't want to lean on Medicaid because I'm going to lose my home if I'm on Medicaid. And as we talked about today, that, you know, we've talked about how the rule about your residence and when it's protected and when it's not protected. We've also looked at how you can really surely protect the house by using that irrevocable asset protection trust. A lot of people think they can't afford long-term care, and we see this a lot of times, especially when one of the spouses is trying to care for the other spouse. They think, I can't afford long-term care, so I'm just going to put it off as long as possible. And these are really the heartbreaking cases, because there's a lot of times where that spouse who's the caregiver has worn themselves out because they think they have to do it all. And if there's one thing that I think we could shout from the rooftops, it's that be aware that there's planning that can be done. Most of our clients, I would say, are middle income clients. So clients who are not, you know, multimillionaires. They're clients who are everyday people with everyday resources, some more than others. But there is absolutely a way to make sure that you or your loved one has long-term care. Appropriate long-term care for their needs. Some people think I should use my retirement savings to pay for my ill spouse's care. Sometimes we do dip into the tax deferred or retirement assets. And depending on which state that you're applying in, you should be really careful of this. So if you think you might apply, especially in the state of Delaware, the healthy spouse, so if Betty had retirement accounts, her retirement accounts would actually be 100% off the table, so not countable. That's not the rule in Maryland, but still, anytime we're liquidating tax deferred or taxable accounts, we want to be really careful and thoughtful about using those assets. A lot of people think that any type of gifting precludes Medicaid eligibility. I think we talked about the 5-year look-back rule, how it applies, and how we might want to leverage that rule to our benefit so that we can gift appropriately while protecting assets. Some people will come to us and say it's too early to plan. I talked about that, right? They don't want to concede that maybe they need to do some elder law planning. But while you're healthy and happy, those are the years that you should be doing doing the long-term care asset protection planning. Some people will think it's too late too, right? They come in and they, you know, Michelle famously in our office had a case where the family came in almost 10 years after the person was admitted into a skilled nursing facility. So he'd been privately paying for his care for 10 years. The family had no idea that any type of planning was available. They thought everything needed to be done more than 5 years before he was admitted. They heard us speak and they came in to see us, and we were still able to protect assets at the last second. So if a family has more than the $2,500 that person's able to keep, there's still planning that can be done. Another thought is that people must be destitute to qualify for Medicaid. I think that comes from the idea that Medicaid has resource rules. You have to be financially eligible, but certainly we've talked about how people who maintain healthy assets can still qualify for Medicaid as long as they do the planning appropriately. Asset protection planning is unethical. That's one that we hear sometimes. I've talked about why we do the planning that we do. I've talked about wanting to set aside that nest egg for the Bobs and Bettys of the world. And that's the primary motivation in creating the types of plans that we're creating. I will also say that we have really good relationships with our local Medicaid caseworkers because we are conscientious, and we probably err more on the side of being a little bit conservative because we know we're going to have to disclose all the planning that we do to the Medicaid offices. And so everything we do is justified by the regulations themselves. I would not suggest a client do anything that wasn't within the rules themselves. Another thought, all elder law attorneys are the same. So this is something that I would just caution people just to make sure that as you're meeting with an elder law attorney, make sure that you're meeting with somebody who really knows and understands Medicaid, VA, probate, because you want somebody who not only creates will documents, right, or other estate planning documents, but knows how it plays out. They help clients implement those plans. So they know the ins and outs. They know exactly how it's going to play out when push comes to shove. And sometimes it's really hard for you as the consumer to know whether you're sitting in front of somebody who's knowledgeable or not. Because I think anytime we meet with a professional, we expect them to know more than we know when we sit down with them. We've actually created a tool that's listed on our website. It's a top 10 questions to ask your elder law attorney. So that would be a great resource. I wouldn't suggest taking it in and quizzing them right in front of them, but it's certainly a resource you could use in advance